Judgment has been reserved in the Constitutional Court application for former President Jacob Zuma to comply with a summons to appear before the State Capture Commission next year. Last month, Zuma walked out of the commission without chairperson Justice Raymond Zondo's permission. The application is also seeking an order declaring Zuma's conduct unlawful and in breach of the Commissions Act.
Keeping true to his word, the former president was a no-show at the Constitutional Court. He came under fire for both disrespecting the apex court and the Commission of Inquiry. The commission argued that Zuma had launched a vicious attack on it to avoid accountability.
Mr. Zuma, through his alter ego, the Jacob Zuma Foundation, is actively attacking the commission. He is also actively attacking the judge, Mr. Justice Zondo. This much is clear at page 138 and 140 of the papers. The vicious language that is employed by Mr. Zuma and his supporters, the Jacob Zuma Foundation, against not just Justice Zondo, but other persons associated with the commission would make one cringe.
Justice Chris Jafta questioned whether Zuma would abide by the order if it was granted.
But why not? He has not even bothered to treat us with respect on your argument. He filed a letter to say, I'm not participating. Why would you think that he would respect an order of this court?
It's staggering. It's truly staggering to think that a former president would also breach an order of this court. It's truly staggering. It defies logic and belief. But nevertheless, this court has held on numerous occasions. The prospect of non-compliance with a future order cannot deter the court from imposing an order that is just and equitable.
The commission argued that Zuma did not have a right to remain silent should an order be granted for him to appear at the commission.
When he appears, he has no right to remain silent. And that also fulfills a self-standing constitutional obligation to account. Otherwise, accountability becomes an epithet, a mere word with no content.
Defending the direct application to the Constitutional Court, Gugaietobi said it would have taken too long to go to the High Court, then to the Supreme Court of Appeal, and then to the ConCourt, by when the Commission's lifespan would have been exceeded. And Zuma would not have answered. Samkeile Masego, SABC News, Johannesburg.
So let's delve a little further into the arguments made there at the ConCourt. Specialist legal journalist Karyn Maughan joins us now. Karyn, a very good evening to you. So let's just first start with that, what Advocate Gugaietobi was saying, that, it would have taken too long to go to the High Court. But one of the judges arguing that this is really a self-created urgency. Did he make a compelling point in pointing this out?
Well, it was an interesting point to raise because two of the justices, namely Chris Jafta and Justice Madlanga, were at pains to repeatedly question the fact of why the inquiry had not, in the circumstances of December last year, when they say it became apparent that Jacob Zuma was not willing to appear before the inquiry, why was he not subpoenaed to appear at that stage? And why did the inquiry insist on embarking upon this process where they actually brought an application for Jacob Zuma to be summoned, which they have not done in the 99 other cases where subpoenas have been issued, and thereby prolonged this process? So this issue of self-created urgency is one of the pivotal ones that this court is addressing, because it will really be at the heart of whether the court believes this is, in fact, an urgent application and that, indeed, direct access is justified. Gugaietobi for the inquiry arguing that Jacob Zuma had not come to the commission on the basis of alleged ill health and had repeatedly stated that he was willing and able to cooperate with the inquiry. But the commission really under fire over here over what simply appears to be manifest special treatment of the former president. And at one stage, Gugaietobi actually stating that DCJ Raymond Zondo had, quote unquote, bent over backwards for Jacob Zuma.
And I want to look at exactly that. I think the time frame, if I'm not mistaken, was somewhere between April and August, where it was raised that why was it, as you mentioned, during this time, a subpoena not considered. So what does the ConCourt have to look into to determine that merit of urgency is, and what is the process and procedure there? If somebody was saying that they were doing their very best to ensure that their content transitions in a manner that will allow at least for some sort of progress.
Well, I mean, the pivotal issue here is that the inquiry is meant to complete its work on the 31st of March. Now, we know that Raymond Zondo had a press conference a few weeks ago where he essentially said, look, we are going to make an application for an additional 3 months to compensate for the 3 months we lost as a consequence of the COVID-19 lockdown. So essentially, they have until the 31st of March in order to get the former president's evidence. And, it's a question of this court saying, well, is this enough of a basis to see this as an urgent application? Have you made enough of a case to actually seek direct access to this court as the apex court? We know Chris Jafta in the hearing today expressing a lot of reservation about the fact that the former president would not be able to appeal it. Of course, Nguya Toby repeatedly pointing out that the former president had chosen to absent himself completely from this process, which he said demonstrated a lack of respect or disdain for the entire legal system of South Africa. But all those hurdles need to be overcome. And in addition to that, of course, the court will need to give its ruling sometime in January in order to enable the former president to be in the witness box in January and February, which is when he is scheduled to appear.
In fact, the words used by Advocate Nguya Toby was a deliberate stratagem in which he said was used to run out the lifespan of the inquiry. Is there a clear timeline or paper trail to serve as a convincing argument of this? I mean, we've heard of these and they've been labeled as excuses, but, it depends from the prism from which you look at it.
Well, absolutely. I mean, Jacob Zuma has taken great umbrage with the inquiry for what he says is suggesting that he was not ill when at one stage last year he did not appear before the inquiry. He said, look, I was overseas receiving medical treatment. I volunteered my doctors to you. You didn't meet them. And he saw that as a major affront. But outside of this medical issue, the Commission has repeatedly asked the former president for information in regard to Eskom and information in regard to the Passenger Rail Agency of South Africa, which he has not supplied. At the beginning of its life, it asked him for an affidavit in response to the evidence of, if I remember correctly, Feki Mentor and Themba Maseko, which he did not supply. When he appeared in July last year and withdrew from the inquiry because he was unhappy about the vigorous cross-examination that he felt he was facing, he then agreed to provide a further affidavit in response to certain areas of interest that were identified by the inquiry. He has not done so. He has also chosen not to respond, and he says that it is his right to do so, to 36 different notices that he has been implicated in the evidence given by some 36 other witnesses. So there is somewhat of a paper trail to indicate that up until now, the president really hasn't done a lot to make good on his promises of cooperation and to provide the inquiry with the evidence that it has asked for from him.
So just finally and briefly, Karyn, what outcome will have what effect?
Well, essentially, I think the Constitutional Court is going to be very reluctant, or appears to be very reluctant, to find that Jacob Zuma's walkout of the inquiry was unlawful. Again, Chris Jafta repeatedly raising this issue of it potentially preempting a criminal process in regard to contempt, which we say the inquiry is said it's going to launch or has launched. And the court, I think, seems to be persuaded that if it does grant direct access and if it does grant this order, it will simply do so in order to compel the former president to appear. The big question really about this right to remain silent, will it grant an order in regard to that? And even if it does find that Jacob Zuma only has a limited privilege against self-incrimination, there's every possibility that, as Dudu Myeni did when she testified, he will simply choose to use that privilege in response to every single question. And to be honest with you, I'm not sure the Commission can do much in response to that.
All right, Karyn, of course, we'll keep an eye on the story as those developments continue. Specialist legal journalist Karyn Maughan.